Today's shiur begins 9 lines from the top of Daf Mem Beis. Before we begin the shiur, let us note that we require for this piece of Gemara certain general pieces of knowledge before we begin. So on the side, you'll notice there's a starred note, and we call it He'orah. On the right-hand side in the margin, we've written the following. Yedia Klolis, a general piece of information. Ein chiyuv keren v'choymesh v'osham, hanikra osham gezelos, v'mi shenishba b'sheker v'achakachoyde. The Torah is, of course, very opposed to people who swear falsely. If a person takes an oath, he swears that he does not owe money, and then he confesses that he swore falsely, he has to pay. Keren is the principal, Chomesh an additional fifth, and an Osham is a sacrifice called an Osham Gzelos. This obligation does not come up unless someone would have to deny a mamon type debt. Mamon as opposed to knas. This is a concept that we've been discussing quite often in our recent shiurim, so as not to belabor the point any further, let us just tell you that the realm of mamon has to do with actual financial market value debts or liabilities, versus knas, which is in the realm of a fine, something that doesn't correspond purely to a market value liability. So that when one swears falsely and then is modeh, then confesses that he did such, he has to pay the wronged party, the principal, an additional fifth, and bring a sacrifice, an Osham Gezelis. And once again, this applies only if the denial was a denial of a mamon nature, a financial nature, as opposed to a knas, a fine. So now, with that background in mind, we also have to bear in mind that when we deal with the topics of rape and seduction and the amounts owed as a result of those wrongdoings, the amounts include both mamon and knas. This is the basic knas we've discussed quite often in our recent shurim, the 50 shekel kesef, the 50 pieces of silver. That's the fine. The other payments, the boishes pagam, the tsar, those are mamon type payments. So now let's take a look first at the Tanaic source at hand. Tanan Hasam, a Mishnah appears there in Masechet Shavuos, Onasto upitiso as biti. A father comes with a claim against a man saying, you raped or you seduced my daughter. Vu omer, lo anasti v'lo pitisi. The litigant says, no, I did not do that. And then the father says, mashbiochani, I want you to swear to substantiate your denial. V'yamar omein, says, that's right, he's a confirmation, I swear to that effect. And then he confesses, yes, I really did those acts. Chayav. So he is chayav, he's obligated with regard to the keren, the principal, the chomesh, the fifth, and the osham, the sacrifice. Rabbi Shimon Poter. Rabbi Shimon holds that he is exempt. She'enu mishalem knas al pi atzmo. The payment of a knas, one does not pay through his own confession. One pays knas only if witnesses come and testify to his wrongdoing. And in this case, since had he come to us immediately with a confession, he would have been exempt altogether from paying the knas, when he denies it initially and then confesses, that does not constitute a shvuas kfiras momon, an oath involving a momon denial. Now, we glance at the side, in the margin, we have a topic heading, Nosei Klali. We indicate a general topic heading that lasts until Daf Mem Gimel Omid Aleph. She'elas Mafteach. We have a key question. Ha'im u'mosai knas shel oines u'mefate mishtana lechoshev mamon. Can it come about, and when, if it can come about, does the knas aspect, the 50 shekel kesef of oines and mefate, does that, and when does it convert into a payment that we would call mamon? The nafkamina, the practical application of this analysis is lischayev mishum kfiras shvua and yerusha. Would a person be guilty of a false oath, which involves when we say guilty of the false oath with its already mentioned outcome of keren v'choymesh and osham, and it has bearing regarding laws of inheritance. The money is owed, let us say, to a father. Upon the father's death, do the sons have a claim on that knas money, that which was originally knas? Then, as we continue on the side of our Gemara Nosei, a immediate topic heading that lasts also till Mem Gimel Amav, Sheilas Abaye. Abaye's question: Eich Yagdir Rabbi Shimon? How will Rabbi Shimon categorize hakofer tvias tashlum knas u'moisif hatovea shekvar hemadaticha bedin? A person is claiming, if you will, a father is claiming a knas payment, and he adds, and he says, I already brought you to court. This already went through a court procedure. And then the defendant then admits kikfiras moment v'chayvalel o kiknasu potter. In a situation where the tovea, where the one placing the claim articulates that I already brought you to court, does the appearance in court convert that knas payment? And certainly the question will apply to not just the mere appearance in court, but the court having ruled that you are chayav to pay that money. Does that affect the nature, the identity, the character of that knas payment? Does that, the fact that the court issued a ruling that you have to pay it, does that make it into a mamon type payment? And if it does, when the litigant denies it under oath, he would then be denying a mamon type payment. So now the Gemara, and note we have a long question. Bo'amine Abaye me Rabba. Abaye asks of Rabba, Ho'imr l'chavero onasto pitisas biti v'madaticha bedin v'nischayavta li mamon. You raped or seduced my daughter, and I brought you to court, and in court they ruled that you are chayav to pay me. V'hu omer, the defendant says, Lo anasti v'lo pitisi v'lo hemaditani bedin v'lo nischayavti l'cho mamon. Each point he denies. He denies it point for point. LeRebbi Shimon Mai, according to Rabbi Shimon, who we saw in the Tanaic source above, that on the basic claim of you owe, the basic claim of you raped or seduced, and the fellow denies that under oath, and then confesses, Rabbi Shimon says he is exempt, because with the simple tavia of Onasto Pidisa, the father was putting a claim in for a knas payment, and the fellow denied a knas payment, and as we said in our introduction, the denial of a knas payment does not result in a chiyuv of keren, v'chomesh, and asham. But now within Rabbi Shimon, who was, we'll say, was lenient or was not in favor of obligating the litigant, according to Rabbi Shimon, what about in this case, And here are the two sides of the question. Kevan di Omad Bedin, since the defendant was brought to court, and Rashi adds, very important, let's read the Rashi to there. Kevan di Omad Bedin, Kvar, since he was already brought to court, V'yave moidi lekamon, and had he confessed at that point, have mishalem, shekvar chayvu bezin rishon, al piedim, since he was already convicted of having to pay that in the original court with the testimony of witnesses. Hashta mamona kafre v'chayev. Now, in his denial in this second court, his denial in effect is a denial of a mamon payment, because as we analyzed before, the confession at this point would not have exempted him. It wouldn't have exempted him from paying. We mentioned that one who confesses a knas obligation prior to appearing in court with witnesses testifying, that would exempt him. That's called moide b'knas poter, but not after he was charged by the court with paying it. So, do we say, since he was oimid bedin, it's now mamona havoi? The Gemara goes on, u'mechayev aleh korban shvua, and he is therefore obligated to bring the sacrifice because of his initial denial under oath. Oy dilma, or maybe afagav de omad bedin knas have, even though he stood in court and they charged him with paying this, it remains a knas. We look at Rashi together. Oy dilma afagav de omad bedin v'i moide have mechayev, and had he confessed after the court ruling, he would have been obligated to pay. Even so, his denial will not lead to the bringing of the sacrifice, since it started off as a basic knas payment. The Torah, when it says a person is obligated to bring a sacrifice because he lied in his shvua, in his oath, that's when you lie about something that initially is in the realm of mammon, like money that is entrusted, or an item that's entrusted, or articles that one entrusts, and a shomer, a watchman, denies it and then confesses, but not in something which is initially a knas, a fine type payment. Omar lei, Rabba responds, Mamona have u'mechayev alei korban shvua. Note that we have a firebox marking around the Omar lei, which is Rabba speaking, and on the side of the Gemara, under the Mivneh heading, Divrei Rabba shomer Mamona have, Rabba's ruling that that which was initially a knas type payment converts into mammon because of the court appearance and the testimony of witness, the initial court appearance and the testimony of witnesses concerning that debt. This point of Rabbah, that it's mammon, is masikin as a Gemara la'irich kol amud haba. This will preoccupy the Gemara through the entire next Omid. You see numbers here 1 through 3 that appear in diamonds. These represent shlavim b'havonas divrei Rabbah. We're going to, in order to appreciate Rabbah, there are stages. You'll notice that we have a little later a dot underlining, and that's hadgoshas habitui mamoina have. We're going to highlight that expression that the payment is now categorized as mamon shemafi eitzel hamisparim 1 through 3. This expression will appear at each juncture, at each diamond, 1, 2, and 3. A house marking is employed, and they're called Aleph through Gimel. These are kushios al shitas Rabbah b'divrei Rabbi Shimon mimikuri shel Tanoim. These represent questions on Rabbah, on Rabbah's version of Rabbi Shimon, and the questions are from Tanaic sources. We now continue with a question. It's a long question. We take in a Tanaic source, and it takes us to the top of Omid Beis. Eisvei, Reb Shimon Omer, Yochol ha'omer lechavero anasto pitisas biti, v'umer lo anasti v'lo pitisti. Can it be that a person was charged with, you raped or seduced my daughter, and the other party says, I did not? Or, Hamis shorcha es avdi, v'omer lo hamis. He's charged with, your ox killed my slave, and the killing of a slave through an animal results in a payment called shloshim kesef. It's a fine that is paid regardless of the actual value of the slave, making it a knas type payment. And the person charged responds, no, my animal did not kill. O shomer lechavero, he palto es shini v'simisaseni. Or a slave says to his master, you knocked out my tooth or knocked out my eye, which in the case of a slave would result in his going free. This is another form of knas, Rashi points out. So let's read from the beginning of the line again. O she'omar lo avdo, or a person's slave told him, he palta shini v'simisaseni, you knocked out my tooth, or you knocked out my eye. And the master says, Lo hipalti v'lo simisti. I didn't do that. V'nishba, in all of these cases, he swears to the effect, to substantiate the denial. V'hoide, and then confesses. Yochel yeh chayev, would he be guilty of bringing the sacrifice, the korban osham? Talmud loymar, now this pasuk is in that very context of when is someone chayev for the keren v'chomesh and the korban. So the pasuk says v'chichesh ba'miso, when someone denies to his friend through an oath, b'pikadon or b'tzumas yad or b'gezel or oshak esamiso, through denial of having received an article to watch, or tzumas yad, that itself is something discussed elsewhere in the Gemara, or theft, or you withheld wages, or motza aveda, or a found article, v'chichesh bo v'nishbal sheker, and in any of these cases he denied and swore to that effect in a lying fashion. Ma elu miyuchodim shein mamon, just like these things delineated in the pasuk, articulated in the pasuk, are essentially mamon matters. Av kol shein mamon, so to anything that's in the realm of mamon, yatsu elu shehein knas, to the exclusion of the things mentioned and the claims put in initially, the claims put in that were featured in this source, the onasto pitisa, or the misas eved, or the knocking out of the limbs of the slave. These are not considered mamon. And we must continue with the essential assumption, my lav b'shomad badin. Is it not so that the cases here involved the person charged had been brought to court and witnesses came regarding those charges, and the Beis Din ruled that he has to pay, and now the fellow is denying under oath, he's denying, he's swearing to that effect that he's not obligated. So what is the claim being made? The claim is being made on these payments that were originally fines, but that the court had ruled you are obligated to pay, and the guy denies it with a shvuah. and the result of all of this that he's exempt. So it's not being viewed as mamon. That is the question on Rabbah, because Rabbah had said that after the Hamodah B'din, after the appearance in court, it converts into mamon. In this source, where if we make this assumption that it was Omad B'din, it does not get converted into mamon. Response: Lo. Rabbah says that's not the case. The assumption that we're making here that there was Hamodah B'din is not so. B'shaloi Omad B'din. The source is talking about a case where there was no Hamodah B'din. It was just a father coming out of the blue to a guy saying, "You raped my daughter," and the guy says, "No way," and would you swear to that? No, yes, and he swears. That's it. No court appearance. Abaye asks, how can you say that? The first part of this source features Omad B'din, so it's within the same Tanaic source. The beginning had Omad B'din. It would leave it to be concluded that the Seif also was Omad B'din. Tikotoni Reisha, as it says in the Reisha, and note by the way that this is a long question that Abai is presenting to Rabbah's answer. What does it say in the Reisha? Ein li ela dvorim shemishalman aleim as a keren. That a person will become chayav a keren v'choymish v'asham. That a person will be chayav to pay the principal, an additional fifth, and bring a sacrifice. I would think, I might think that that's restricted to those kind of payments where all that's expected of a person is to pay the principal, and then when he swears and swears falsely and admits, he'll have to add the keren, the chomish, and bring a sacrifice. What about the denial of the following? Tashlume kefel, the double payment that is made in the case of a theft, a stealthful theft. Tashlume arba v'chamisha, the multiple payment made if the item stolen is subsequently slaughtered, if it's an animal slaughtered or sold. The payments made for rape, seduction, or false accusations concerning one's wife's fidelity. Minayin. From where do we know that those also, if one denies, without getting into all the examples, let's just take the example of kefel. If one denies owing the double payment for having committed a stealthful theft, from where do we know that that would also result in keren v'chomish v'asham? Talmud lomer umualo moal riba. The double expression includes more than those kind of payments that are purely mamon in nature. We're including kefel. Now, kefel is a form of knas. It's a double payment. It doesn't reflect the actual market value of that which was stolen. It's double. Hey Chidami, what are the circumstances behind this source? If there was no court appearance, if there was no court appearance, there would be no obligation to pay double. Since when does a person have to pay double? He pays double because he had stolen. He was brought to court, and they proved through testimony of witnesses that he committed the theft. So then he pays kefel. But without a court appearance, where's the kefel? Elapshita b'shomad b'din. This Reisha section that we have in the frame we just saw is talking about a case of someone that had appeared in court and was charged by the court to pay up all of these things. Umi de Reisha b'shomad b'din, and just like the Reisha was that, Seifa nami b'shomad b'din. The section that was quoted at the bottom of Omar Aleph, which had Rabbi Shimon at the beginning of that source, with the father saying Onasta Piti says Piti, etc., is also a case of Omad B'din. And we underline the Seifonami B'Shomad B'din. This reinstates the problem, the Kasha on Rabbah. because we saw there it was Omad Bedin, and it was still viewed by Rabbi Shimon as Knas, not Momon, as Rabba wanted to say. Rabba now responds. Note, we have a long answer. Very interesting response. We have it noted with an aleph, and a few lines later you see a beis. There are like two stages in Rabba's comment. Omarle, Rabba says to Abaye, I could have told you, I could have answered you very simply, Reisha b'shomad bedin, and therefore we see that he is chayav, he is obligated to the Keren Chaimish Vasham. The Seifa, which indicates exemption b'shalom ad bedin. The Kula Rabbi Shimon he, and the entire source is in accordance with Rabbi Shimon, which is the opinion that I originally responded. Within his opinion was my original response, where Rabbah appeared in the firebox. And if I tell you this, so then it's all in accordance with what I originally said. There's no question on me. However, this answer, if I were to give this answer, this Aleph answer, 2 lines ago, he says, I could have answered you this, and it would be great for me, but it's a difficult answer. It's shinir dechiki, means it's a forced answer. Why? The imkain, if I were to tell you that the entire source, the Reisha and the Seifa, now the Reisha, the beginning appeared here, a few lines up, where we squiggle on Reisha, 3rd line from the top, that was the beginning of the source. The end of the source was the frame section at the bottom of Omid Aleph. And you know what the problem is? The imkain, amrisli, if I would have told you that the whole source is altered by Rabbi Shimon, so you would have said to me, a very technical objection, but it's an objection all the same. Listni, Reisha, Rabbi Shimon Omer, the opening should have read, Rabbi Shimon says, Listni Seifa, or at the very end of the source, it should have said Divrei Rabbi Shimon. And all of this was Rabbi Shimon. It doesn't appear like that. The Reisha does not open up with Rabbi Shimon Omer, etc., and so forth. Nor does the source close with Divrei Rabbi Shimon. What does it have? It has Rabbi Shimon smack in the middle. Elo Rabbah goes on to say, Kula b'sha'omad bedin. The entire source is featuring a case where the defendant had appeared in court and witnesses had testified to his being obligated to these things, and the claims that are being put in are outside of that court and in front of a different court. Where the guy says the claimer claims, you owe me these things, and you appeared in court elsewhere and you didn't pay up yet. So the whole source is dealing with Omad Bedin, the Reisha Rabbanan. The Reisha is in accordance with the Rabbanan. They hold Chayev, that it's considered a Mamon payment. The Seifa Rabbi Shimon, and the Seifa, which speaks about exemption, is in accordance with Rabbi Shimon. Now wait one second here. That's not very good for Rabbah. If you have Rabbi Shimon being the author of the Seifa, and the result is that there's exemption. After all, Rabbah himself said regarding Rabbi Shimon that after a court appearance it becomes mamon and there would be no exemption. Rabbah continues to explain, Umodina loch le'inyan korban shvua, and I will concede that there is exemption even though there was a court appearance. I will concede that there is no sacrifice that has to be brought because of that false denial. The Rachmana Patre, the Torah exempts in mivachichesh from that pasuk. That the pasuk that we read at the 3rd line from the bottom of Omen Aleph. Based on that, he will not have to bring a korban. A korban is brought only for those kind of money claims that were originally pure mammon, not something that converted into mammon. V'chi ko'amino mamon have, and that which I said mamon have regarding those claims that were originally knas, and as a result of hamoda bedin, it becomes mamon lahorisho lebonov. The practical ramification of classifying it as mamon is that it would now be money that, in the event that the father dies, the sons would inherit, that would be able to receive the payment from the offender. Rashi, a few lines up from says Lo Risha Lebonov, Misha Omad Bedin Umeis, Achel Hispik Ligvois. If there was a court appearance and the court charged the offender with paying, and the claimer died before he actually collected it, the sons, in the case of rape, not the woman herself, but the sons or her brothers would be entitled to receive that money in place of the father. So it turns into mamon, whereby it becomes subject to the laws of inheritance. Esvei, Rabbi Shimon Omer. Again, we are asking on Rabbah. We have a Tanaic source featuring Rabbi Shimon Omer. Im lo ispiko ligvois ad shemei so'av, harei hein shel atzma. This is from the Mishnah, back on Mem Aleph Amid Beis. Rabbi Shimon says that if the collection was not made in the case of the let's say seduction money, if the collection wasn't made the ligvos is an actual physical collection until the father died, so then the money will belong to her, to the girl. V'i amris momon havi l'rish lebonov. If you say that after a court appearance it becomes something subject to the laws of inheritance, li'atzmo amai, why is she getting it? We mentioned in a previous year that as far as the laws of inheritance are concerned, when a man dies leaving sons and daughters and a daughter, the laws of inheritance state that only the sons inherit, not the daughter. So what is the Mishnah saying when it says that she gets the money? But according to you, Rabbah, it becomes mamon for the sons, for her brothers to inherit. Reading again in the Gemara, the payment should go to the brothers. We have a response. Omar Rava. Rava responds, we'll say on behalf of Rabbah. Omar Rava, Hai Milsa Kashoy Ba Rabbah Rav Yosef Esrin V'Tartin Shanan. This matter was a point of difficulty for Rabbah and Rav Yosef for 22 years, below Ifrik, and it was not resolved Adi Yosef Rav Yosef Bereisha, until Rav Yosef, after Rabbah died, Rav Yosef assumed the leadership of the academy, of the yeshiva, Upirka, and he answered, Shaini Hasam. There, it's different. As far as the inheritance issue is concerned, it's different. The Omar Kro v'nosan ho'ish hashoichi v'imo lavi hanaro chamishim kesef. The payment, the fine for having committed the rape is spelled out in this pasuk, and we interpret lo zichsa torah la'av el mishas nesina. The father doesn't have rights, doesn't have control or ownership of the money until he actually collects it. Nesina is the actual giving of it. So that it's not subject to the standard laws of inheritance, according to Reb Shimon, if the father didn't actually collect it. And that which Rabbah said, that the mere court appearance converts it into mamon in order for the laws of inheritance to apply b'shar knossos. That is true with regard to other fines, but not the rape money. The knas of oines and mefata, the knas, the 50 shekel kesef of the rape or seduction, even after Amoda Badin, is not considered mammon. There's a bracketed section, and we recommend skipping it initially, in order for the question that follows the brackets to be attached to what we just said. So let's do that. We have a trapezoid shape that appears. Ihachi. If this is correct, that the knas of oines and mefata is different, based on this pasuk of Nosan o isha sheichi v'imo avina hara, then the source on Omed Aleph, which indicated exemption, should have cited this pasuk and not the pasuk that it did cite. Ihachi talmud lo mar v'chichesh. The source on Omed Aleph. We have a little star, by the way, to the right hand side of the Gemara text to tell you to go back to Omed Aleph, and you can see what this is referring to 3 lines from the bottom of Omed Aleph. So instead of the source which indicated the non-mammon element, instead of reading the chichesh, and there the entire pasuk was quoted, Talmud lomar v'nosan mi boyale. It should have read v'nosan o isha shochi bima, that until the father actually collects it, it's not considered mammon. Now let's go back over the bracketed section. In the meantime, because we're involved with a rather complicated sugya, so just a little recap. In the meantime, focusing on stage 3 in the diamond, Rabbah had mentioned that according to Rabbi Shimon, after Hamoda Badin, that which was originally knas gets converted into mammon. We had saw Rabbah mention that idea that it gets converted into mammon has relevance regarding the laws of inheritance. And yet, we saw in house number 2 a challenge to that idea, where we'll say the rape money did not get converted into mammon to be subjected to the standard laws of inheritance by the fact that the Mishnah says the girl, the sister, inherits it upon the death of the father. So Rabbah in stage 3 responds that after Hamoda Badin, something that originally is knas gets turned into mammon regarding the rules of inheritance. That's true, but regarding other kinds of knas, not regarding the knas of oines and mefata. And why did Rabbah say that? Because of a pasuk which said v'nosan o isha shochi vima. It doesn't become the father's until he actually physically collects it, and not at the point that the court rules that the offender has to pay. Now in the brackets we read Ela me'ata. If this is correct, Gabi Evet Dichtiv, regarding the death of a person's slave at the horns of an animal. Because an animal killed someone's Evet, the owner of the animal must pay 30 kesef. And the pasuk says kesef shloishim shkolim yitain la'adoinov. Notice we dash the word yitain, similar to the word v'nosan above. Hachinami, are you going to say here too, lo zich sater lodoin ela mishas nesina, that the owner of the slave doesn't have a claim to that money until he actually receives it? That is not true. So the Gemara answers yitain l'chud v'nosan l'chud. The words are similar, but they're not the same. Yitain has a future connotation, which will indicate that it's mammon even before the owner actually receives it. And v'nosan is a past tense expression, which implies that it doesn't become the father's until he actually received it. The Gemara continues with the trapezoid shape on the side under the mivneh. we've indicated that this trapezoid are kushos hamevusasas al mashikotoni besof habraisa b'shulei amid aleph. These are questions that relate to that which appeared at the end of the Tanaic source at the bottom of Amid Aleph. So the Gemara asks, Ihachi, and let's glance at Rashi. There's a little star, a few lines up in Rashi. Yachi, the shiny knas deinusim mefat mishar knosses. As HaRabba is claiming now that the fine of the rape and seduction is different than other knas type payments. That even after the court ruling on it, it doesn't become mamon. So if that's true, so then the Gemara text continues. Instead of the source citing that pasuk, the Rashi elaborates on this a bit. The Rashi where we left off, is read with a tone of wonderment. What caused the Gemara to speak about the exemption based on the pasuk of v'chichesh? Midolo domi l'tzumas yad l'meve ikut chilasa mamon, since the oinus and mefate knas is not like the tzumas yad payment, which is a type of payment that initially is mamon. Oinus and mefate are not initially mamon. Tepuk lei dahashtonami lav mamona hu. You should conclude that now too, even after the hamoda bedin, it's not mamon. The Rachmon Amar v'nosan. The Torah used that word. It doesn't become the father's until he actually takes hold of it. So why did the source cite? We'll call it a pasuk that's not relevant. Let's continue in the Gemara text. Omar Rava ki itzrich v'chichesh. The citation of that pasuk, v'chichesh, in the context of the oinus and mefate, and not the pasuk of v'nosan, kegoin she'omda bedin ubogra umeisa. That's a case where the offender had been brought to court and charged. The girl, in the meantime, became a bogeres. She went above age 12 and a half. Umeisa, and then she dies. The hasam he koyoris avia mina dida koyoris. In that case, the father is inheriting from the daughter, because at the point that she becomes a bogeres, the payment should have gone to her. Let's take a look at Rashi. According to Rabbi Shimon, didahu, it actually belongs to her. Just like he argues in the Mishnah, a case where the collection was not made during the lifetime of the father. If that happens, if there was no collection during his lifetime, she receives the payment. Here too, Rabbi Shimon takes his personal stand against the Chachamim that if collection was not made until she became a bogeres, she gets the money. The Tanakama said it belongs to the father. Rabbi Shimon Arehu shel atzmo, it belongs to the girl. V'im meisa achreichein yoris lo avia mikoach dida v'mamon gomor. If she dies afterwards, the father inherits from her, and that's straightforward mammon. V'afagav delo motel yada, even if it didn't get to her hands. To the gavi dida lo havi shiny mishar knosses, regarding money that she would be entitled to. the oinus and mefata payments are not different than other knossos. The mishas hamoda bedin mamona have. It becomes mamon, in fact, from the time that the court charged the offender to pay it. And in the event that she was in the position to receive the money and she died, yoris who the father inherits kol schus shahoya lo bo, all claims that she had in those monies. Hilkach mi v'nosan lo motzi lemiftre, that now the v'nosan pasuk is irrelevant, because the v'nosan pasuk spoke about actual collection. You don't need actual collection in this case. V'nosan v'shas mi v'chichesh umishum di'ikoro knas. The source cited the exemption based on the pasuk of v'chichesh, because you're dealing with money that was originally knas, and in that sense it's different than standard mammon. And as we explained earlier, that exemption had to do with exemption from bringing a sacrifice. Oh, that is quite a bit that we just learned in the Rashi. It deserves an extensive review, but we will go ahead now in the Gemara itself. Ihachi, we're at the second trapezoid form. Ihachi, that the source is actually talking about Omad Bedin, and it got converted into Mammon, then why does the source, and use the arrow that you see, and it tells you to go back to Omad Aleph, the bottom line that was actually dashed, underlined, the bottom line of Omad Aleph. If everything we've said till now is in fact the case, Rabba, in other words, if we're going to superimpose Rabba's explanation that the source was talking about a case that there was actual Omad Bedin, and it got converted into Mammon, and the exemption is only so insofar as the Korban, but as far as inheritance is concerned, it becomes Mammon. Why did the source say Yotzu Elu Shein Knas? Mamonhu, the source read that though the payments made, or the payments made or featured in that source were knas, but they're not. Once you omad bedin, you say it gets turned into mamon. So why didn't it say that? Why did it say yotzu elu shein knas? Amar Rav Nachman bar Yitzchak yotzu elu she'ikoron knas. It's true they are mamon, but they started out as knas. Esvei, again, a challenge to Rabbi Shimon. That is a challenge to Rabba and his explanation of Rabbi Shimon. Esvei, Rabbi Shimon poiter she'eino mishalem knas al pi atzmoi. We have an arrow that you can see to the left-hand side of the Lord text, indicating to look back at Omad Aleph. So if you do that, you can see that we're talking about referring to the source that we opened up today's shiur with. Father had claimed that someone that you raped my daughter, and the fellow denied it. He swore to that effect and then confessed. Rabbi Shimon says he is exempt because a person does not pay a knas al pi atzmo. So now the Gemara, we're quoting from that source. Eser Reb Shimon poiter she'eino mishalem knas al pi atzmo. Why is there exemption according to Reb Shimon? And of course, following Rabbah, Taima delo omad bedin. He wasn't brought to court and subjected to the testimony of witnesses against him. Then, if it's that early stage, he hasn't come to court, he can be modeh, he could have confessed and achieve exemption. Ha omad bedin. However, had he been subjected to a court ruling which follows the testimony of witnesses to his having committed the act, the mishalem al pi atzmo, under those circumstances, it doesn't help for a person to confess anymore. If after he was omad bedin and he would later tell us, the court ruled against me that I have to pay, he'll have to pay. The concept of confession and resultant exemption doesn't apply anymore. Well, korban shvua nami mechayev. There should have been a sacrifice also. Note the double star, and if you skim up to the upper part of the page, you see there a line that reads Sefer Rabbi Shimon, Modina lach linyan korban shvua d'rachmona patre mevachichesh. That even though there was hamoda bedin, he would be exempt from the korban shvua. Here we're coming to a conclusion that differs from what Rabbi Shimon said above. We're coming to the conclusion that if he would have confessed prior to Amad Bedin, so then he is exempt. But if he confesses after Amad Bedin, he won't be exempt from the Korban Shvua. And yet, Rabbo said above that I can see that regarding Shvua, he's exempt even after Amad Bedin. The Gemara answers, and note this is a long answer that takes us to the second line from the top of Mem Gimel Amud Aleph. Rabbi Shimon l'divrayim d'Rabbanan kamar lahu. Rabbi Shimon is not reflecting his own opinion. He is speaking to the Rabbanan on their terms. And he's saying as follows: L'didi afagav d'omed bedin rachmona patre mivachichesh. As far as I am concerned, payments that start off as knas, even after hamoda bedin, they do not get converted into mammon insofar as obligating him to bring a sacrifice if he swears falsely concerning that. Ela l'didchu, but according to you, the Rabbanan, odu li mihas, you should at least concede to me, hechodoloi omad bedin, where there wasn't any court ruling yet, there wasn't any testimony of witnesses yet. When a father claims on nasto pitisos biti, again we're making reference to the source that we saw, the upper part of Mem Beis Amud Aleph, where a father put a claim in. Rabbi Shimon is saying to the Rabbanan, just to repeat ourselves, as far as I am concerned, even after Amad Bedin, if he denies through an oath and then confesses, he'll still be exempt from the korban, from the sacrifice. But you, the Rabbanan, who don't see eye to eye with me on that, you should at least agree that prior to Amad Bedin, where the claim of onasto pitisos biti is made by the father is basically coming with a claim of knas. Knas kotova. Umoide b'knas poter, and a man who confesses that he owes a knas is actually exempt, and therefore when he swore to the father and then subsequently admitted that he swore falsely, he should be exempt. The Rabbanan Savri. The Rabbanan's response to that is ki kotova, when a father comes with a claim against the offender, you raped or seduced my daughter, the father is claiming boishes upagam kotova. He's claiming the other payments. His interest is in the boshes payment, the payment for the embarrassment, or the payment of pagam, the depreciation value. Those are mammon payments. Those reflect an actual market value loss. And being that they're mammon payments, when the offender swore falsely, he was being koifer b'mammon, he was denying a mammon payment. Denial of a mammon payment results in the chiyuv shvua, the chiyuv korban, the chiyuv, the obligation of bringing a sacrifice for having sworn falsely. What are the Rabbanon and Rabbi Shimon really arguing about? Looking at that very case, at the source with which we open today's shiur, the Tanaic source at the upper part of Mem Beis Amud Aleph, father claims, Nasta P'tisus Biti, father, and the fellow denies. According to Rabbi Shimon, he's viewing that as a denial of a knas. Prior to Hamodah B'din, certainly, according to Rabbi Shimon himself, even after Hamodah B'din, but prior to Hamodah B'din, which is the point at which we're holding with right now in the Gemara, that the Rabbanan of Shimon are arguing at that point in time, prior to Hamodah B'din, Rabbi Shimon is saying it's a knas claim, and the denial under oath and subsequent confession does not result in a korban shvua. The Rabbanan say it is a mamon claim, because the father is essentially putting a claim in for the boishas upagam payment, not the 50 pieces of silver. So what's the underlying point of controversy? What's the explanation of this machlokes? Omer Rav Papa, Reb Shimon Sovar, lo shovik inish midi de kitz v'tova midi de lo kitz. A person, in this case the father, would not leave off. Shovik is to abandon or to leave off a claim of something that is fixed, a fixed set amount. Doesn't need any evaluation or estimation or assessment. It's a fixed Torah amount, 50 pieces of silver. A person wouldn't pass up on a chance to get a fixed amount and opt to focus his claim on something that's not fixed. Like boshas and pagam, they have to be evaluated and assessed. So that in terms of we're dealing with the machlokes here, we'll call it in psychology. What do people focus on when they make their claims? And specifically in the case of a type of claim that has a combined as both knas and mamon within the general claim. So according to Reb Shimon, the focus is on midi de kitz, something that's fixed, the knas aspect, the 50 pieces of silver. For Rabbanan Sabri lo shovik inish midi the chimoidebe lo miftar, the tova midi the chimoidebe miftar. The Rabbanan say people, when they make claims with a certain conservative attitude. Namely, they take into consideration that certainly prior to Hamodah B'din, if the person confesses owing the money, there's certain times, and we've mentioned this many, many times already, like in the case of knas, where if a person were to confess prior to Hamodah B'din, he won't have to pay at all. Why would a person, the Rabbanan say, why would a father claim from someone a type of payment that if the guy were to turn around and say, yeah, that's right, I did it, the father wouldn't receive a dime. Rather, a person, the father, will put a claim in for that kind of payment that even if the fellow would admit to his offense, he still won't be exempt, as is the case with boshas upagam. He'll have to pay anyway. So as far as the Rabbanan are concerned, that's what the father is claiming, and when the offender swears falsely that he doesn't owe it, he's denying a mamon payment, because that's what the father was putting his claim in for. My hope is that this particular sugya, which in my humble opinion is a very complicated sugya, featuring Rabbah and his explanation of Rabbi Shimon that as a result of Hamodah B'din, that which was originally a knas payment gets converted into mamon. With regard to what did Rabbah say that? So we went through this in stages. We saw that he did not say that it becomes mamon with regard to the korban shvua. He did, however, say that with regard to the original knas payment being converted into mamon with regard to laws of inheritance. And even within that, we saw a distinction made between the claim of the knas of oines umefata versus other kinds of knas payments. A distinction was made, and there was a basis of that in the scriptures, the pasuk that spoke about V'nosan, and the question then arose, why did the source at the bottom of Mem Beis Amud Aleph cite the pasuk of V'chichesh? And Rabba gave an answer to that as well. So at the end of this sugya, Rabba has answers to the questions that were raised against him. For further fluency, of course, one must review this, as is the case with all Gemaras that one learns. With that, we conclude our shiur for today.